Welcome to This Explainer. Today, we're diving into a piece of high-stakes constitutional drama that literally tests the very foundation of how a democracy operates. We're looking at a landmark case from South Africa's constitutional court called Swartbooi versus Brink. Now, I know what you might be thinking, legal theory? But trust me, this isn't just dry textbook stuff. This is a story about money, power, massive bureaucratic blunders, and the incredibly delicate balance that keeps a government running. It asks a really fundamental question about the people we elect to represent us and what actually happens when they make decisions that a judge deems completely unacceptable.
I want you to just imagine a scenario for a second. You go to work, you sit in a meeting, and you cast a vote on a policy decision. It's your job to vote, right? But later on, a court steps in and decides that the decision you voted for was so flawed, so fundamentally wrong, that you shouldn't just get a slap on the wrist politically, you should be personally, financially ruined. Should elected officials actually have to open their own personal bank accounts to pay the legal costs for a vote they cast in a democratic assembly? I know it sounds like some wild hypothetical thought experiment from a college political science class, but no, this is a very real, very terrifying situation that actually went down. And that brings us to this number 18. 18 democratically elected members of the Nala Local Municipality Council found themselves staring down exactly this reality. The wild part? They weren't even the primary targets of the initial lawsuit. But because they supported and voted for two specific, highly controversial council decisions, they were suddenly on the hook. The very real prospect of personal financial ruin was knocking at their doors, quite literally, just because of how they raised their hands in a council chamber.
So to understand how they even got there, we really have to look at the initial ruling. The Free State High Court didn't just disagree with the council's decisions, they absolutely eviscerated them. The High Court stated that the decisions could not reasonably have been made and were, quote, characterized by undertones of racism and malafades, which is just fancy legal terminology for bad faith. Now, to be clear, we are absolutely not taking sides on the underlying politics here. We're strictly looking at how the High Court's explosive reasoning set a massive legal precedent. The judge essentially looked at them and said, your conduct was so unacceptable that you lose the normal protections of your office, and you must pay the legal costs out of your own pockets.
Section 1. A procedural puzzle.
Okay, let's dive into this, because before the highest court in the land could even touch the monumental question of whether politicians can be bankrupted for their votes, this entire case almost fell apart over paperwork. Let's trace the legal hierarchy these counselors tried to navigate. They started at the Free State High Court, right? That's where they got hit with that devastating personal cost order. Naturally, they wanted to appeal. So they climbed to the next rung on the ladder, the Supreme Court of Appeal, or the SCA. But the SCA looked at their petition and just flat out refused to grant them leave to appeal. They shut the door. Completely desperate at this point, the 18 counselors took their case to the absolute top, the Constitutional Court of South Africa. Now you'd think, when you're fighting for your political and financial life, you hire the best legal minds, right? But as you'll see, even top-tier legal teams can trip over bureaucratic tripwires. When the counselors filed their appeal to the Constitutional Court, they used Rule 20. Rule 20 is the specific procedure for appealing a decision made by the Supreme Court of Appeal. But there is another rule, Rule 18. And Rule 18 is the procedure for appealing a decision from a lower court precisely when the SCA has refused to grant leave to appeal. The appellants thought they were appealing the SCA's refusal? Well, they were wrong. Now, what's really interesting about this slide is exactly why their use of Rule 20 was a massive procedural error. Justice Yakub, who was writing for the Constitutional Court, pointed to an older precedent known as Mfahalele's case. In this case, established a really fascinating logical rule. If the Supreme Court of Appeal refuses a petition for leave to appeal, that refusal is not a decision on the merits of the case. It is literally just a refusal to hear it. Therefore, you can't appeal the refusal. Instead, you have to go all the way back down the ladder and appeal the original High Court's decision directly to the Constitutional Court. Because the SCA refused them, the counselors should have used Rule 18 to appeal the Free State High Court's judgment. Basically, by using Rule 20, they failed the wrong paperwork for the wrong rule against the wrong court order.
Section 2. The constitutional dilemma.
So at this point, the case is hanging by a procedural thread. But the Constitutional Court had to look past the paperwork and realize what was actually at stake here. This is where we shift from a bureaucratic maze to a massive underlying philosophical question about democracy itself. You see, the 18 counselors weren't just arguing that the High Court got the facts wrong. They were claiming a fundamental legal shield. They invoked Section 161 of the Constitution, which, alongside Section 28 of the Municipal Structures Act of 1998, grants specific privileges and immunities to municipal councils and their members.
Think of it like this. This immunity is designed to allow elected officials to actually do their jobs, to debate, to argue, and to vote without this constant looming fear of personal civil liability. It's essentially the armor of a public representative. And this brings us right to the core of the democratic stress test, the separation of powers. I really want you to think about this for a moment. Just imagine the absolute chilling effect on free speech if a judge, so a member of the judiciary, could financially ruin a legislator, a member of the legislative branch, simply for casting a controversial vote. If politicians are terrified of losing their homes just because they vote the wrong way, they're going to stop voting their conscience. They stop representing their constituents. The entire deliberative process of government would just freeze up. The judiciary would effectively hold a financial veto over the legislature, and that's a huge problem. So, the crucial point is that Justice Yakub and the Constitutional Court looked at this case and saw unprecedented democratic implications. This wasn't just about 18 people in the Nalo local municipality anymore. This was about freedom of speech for all elected bodies. It was about maintaining that strict separation of powers we just talked about. It was about the very functioning of municipal councils across the entire country and defining the exact specific circumstances under which public representatives can ever incur personal liability. These issues, as the court noted, had literally never been decided before. Section 3, the interests of justice. With stakes this high, the Constitutional Court is now staring down a monumental constitutional question, but they still have that glaring paperwork error from Rule 20 sitting right there on their desks. So how do they resolve this? Well, this brilliantly illustrates a vital safety valve built into the legal system: condonation. Condonation is basically when a court officially forgives a procedural noncompliance. The appellants literally begged the court to condone their mistake with Rule 18. The standard for granting condonation is whether it is in the interests of justice to do so. The court had to weigh a technical rule violation on one hand against the incredible opportunity to settle a constitutional crisis on the other. The decision? It wasn't even close. Justice Yakub delivered this incredibly powerful rationale, stating, "The issues in the appeal are of importance to the functioning and growth of a constitutional democracy." He recognized that a ruling on this would impact the conduct of every single municipal council member in the entire nation. Because the overarching stakes were simply too high to ignore, it was overwhelmingly in the interest of justice to forgive the paperwork error. Consequently, on November 21, 2002, the Constitutional Court officially granted the appellants leave to appeal. Which leaves us with this final, lingering thought. Swartbooi versus Brink forces us to confront the delicate fragility of democratic systems. On one hand, we absolutely demand that government officials be held accountable for decisions made in bad faith or tainted by racism, for sure. But on the other hand, if we strip away legislative immunity, do we just paralyze the very democratic institutions we rely on? Where is the true balance? As this explainer highlights, it's a tightrope walk, and the rules that govern it matter way more than we might ever realize. Thank you so much for joining me to unpack this fascinating source material. Stay curious and keep questioning how our systems truly work.